We had actually had discussions with this bill last session, and we actually said that we were willing to help to rewrite this and put some changes in there. We haven't seen this bill since it was brought forward now.
And I also want to put a particular thanks to the chairman and to the Second Amendment Coalition and the Rhode Island Coalition Against Gun Violence and various law enforcement people and the AG and the public defender and everyone who sat in very hot, very long meetings last year to come up with the language in 5872 that everyone could agree to, at least last year.
We did have a roundtable discussion last year, and all the major stakeholders were involved in this, including the police community, the prosecutors, the public defenders. The ACLU issued a letter. I was there, Rachel, Joey Lenbeck from the AG's office, and two representatives of the Second Amendment group. But here I am sitting now, a year later, and I find it rather incredulous that groups are testifying that this is a bill that they don't support. I've heard comments that it's well-intended or that someone didn't get notice about this bill.
She doesn't specifically state that the petty misdemeanors are out on this one, so this one would encompass all of 1229-2. Petty misdemeanors, just to make sure everybody's aware of this, is a disorderly conduct which has a 6-month penalty on it, and refusing to relinquish a telephone, which has a maximum penalty of 90 days.
I know that there's been some confusion around misdemeanors and petty misdemeanors. Those are two separate legal categories, just like bookworms and worms are not the same thing just because they have one of the same words in there. Our Chapter 11 clearly defines that there are petty misdemeanors, there are misdemeanors, and there are felony, and there are not overlaps between those categories.
Protective orders are issued in family court, and there are some attorneys on that are here. There are also attorneys that are in the Senate. They realize this. When you walk into family court, most of the judges, whenever they're talking about any type of protective order, any type of order that's restraining or a protective order that's put in place with a divorce, the judges are very, very liberal. They will err on the side of caution, and they will issue a restraining order if they think there's any type of problem that's going to be happening.
You also might hear a lot of people saying that judges give out restraining orders like candy, and minimizing the sort of violence that people go through to get a restraining order. It is true that oftentimes judges will err on the side of handing out temporary restraining orders. That's the way the system's set up. That hearing where both sides can say why they think there should be a restraining order, or why they don't think there should be a restraining order, where they can dispute the facts that are going to be the basis for the restraining order. And at that point, the judge can issue a final order after that due process has been upheld. And it is only at that point in Rhode Island that firearm restriction can be put in place.
That restraining order kicks in here, and now you are locking the judge's hands that even if there's no nexus to a firearm, none whatsoever, there was no allegation that a firearm was ever used, the judge has to order the firearms be turned over. People
will bring up the fact that in many of these cases there wasn't a gun involved. There's no allegation that someone has had a gun held to their head. We think that if someone is routinely showing that they have power and control over ending your life, knowing that they have a gun is an inherent threat, whether or not they have used that gun in any way. And certainly if they've been convicted of domestic violence, they're showing that they are not capable of being an ethical gun owner the way that so many other people are.
The word is shall. It's been changed in there. It used to be may. It says after notice and opportunity to be heard. Well, if you're going to say after notice and opportunity to be heard, the judge still shall turn over the firearms. What kind of notice are we having? What kind of hearing are we having?
You know, it's actually very common in other states that it is a shall issue. 5655 is actually very similar to legislation that has passed all around the country, including in states like Louisiana, where, you know, the gun culture is a little bit more, as a former Southerner, I can say, you know, very much a part of the culture down there. And they found this very reasonable.
Most of the attorneys that are here know the seminal case we have in Rhode Island, State versus Conti. State versus Conti is a case that happened. Mr. Conti and Mrs. Conti were in a divorce. She secured a protective order from the family court during the divorce. Mr. Conti was at the post office leaving. Mrs. Conti was walking in. He held the door open for her and said, "Hi, Liz," when she walked by. The next day, he's driving down the street. She's going the other way, and he waves to her. Doesn't say anything. The day after that, he's in the post office. She walks in. He takes one step toward her and says, "Hello, Liz." She called the police, had him arrested. He went to court, had a trial, and lost.
I think there's also going to be some minimization of what a restraining order entails and what saying hello, I hope you're having a good day, I love you, to someone who has been in such fear of you that they have gone and gotten a restraining order means. For those of us who have had healthy relationships in our lives and are lucky enough not to know too much about this side of the world, it seems really reasonable that even in the most animosity-filled divorce, you should be able to still say, hey, can we talk about this logistical issue with our taxes? I'm bringing you a coffee at court just to be nice. To the person who always got a Starbucks latte the morning after they were brutally beaten, a Starbucks latte means something different. It can be an inherently violent act to violate a restraining order. At the very least, what it says to that victim is, no court can hold me back. No police can hold me back. You may think you have them on your side, but I can get to you whenever.
What we're seeking to achieve in this bill is simply to bring the state of Rhode Island law into conformity with federal law. Already, under federal law, if you commit a misdemeanor, a domestic violence misdemeanor, you are barred from owning your firearm for life. The problem here in Rhode Island is that that is not being prosecuted at the state level because our Rhode Island law is not in conformity with that, and because the federal prosecutors don't intervene, it's just not practical to intervene in the case and prosecute for that one minor issue. I don't mean minor in the sense of its importance, but it's a singular issue.
I want to give you an idea. I think that people are thinking this could be any number of cases. There's so many domestic violence cases each year. This would apply to just about all of them. There are about 4,500 domestic violence cases disposed in district court each year. About half of those across the state are dismissed or pled down to non-domestic charges. Another 435 last year were filings, meaning that they were not convictions. Another 770 were probation only with counseling, which means that they were also not convictions. So we're actually talking about a smallish number of the total number of cases that reach a conviction status each year. And as any prosecutor, law enforcement, attorney general, defender in the room can tell you, by the time someone gets a conviction, they've either, in general, committed a felony assault that has now been pled down to a simple assault and given the maximum misdemeanor sentence, or this is their 7th or 8th time being arrested on this.
And don't get me wrong, we are not supporting in any way with the Second Amendment Coalition, the firearms community, that we advocate anything for domestic violence. It should not be condoned, supported in any way.
This is a real issue, a real concern for Rhode Islanders. We need to make sure that we take firearms out of the hands of abusive people. It's a qualitatively different issue than ordinary misdemeanors. That's my testimony. Thank you.